Welcome back to Good Law, Bad Law. My guest this week is George Bochetto. He is a heavyweight, that is, former boxing commissioner in Pennsylvania and a well-known trial lawyer in Philadelphia and an expert in defamation and the topic of our podcast today, non-disclosure agreements. This is a big, big issue right now with the Stormy Daniels scandal, President Trump, his attorney Michael Cohen, Stormy Daniels' lawyer all over the news. But what is a non-disclosure agreement? We have a copy of the non-disclosure agreement that's at issue there, and we really dissect it and try to understand what is going on with this, what's the purpose, is it enforceable, what are the terms, and what does this suggest about the future of contracts to hush up and keep quiet those involved in bad acts. You won't want to miss this episode. Stay tuned. I hope you enjoy. My guest today is George Bochetto, who is a trial lawyer and an expert in defamation cases, and specifically the topic we're going to talk about today, non-disclosure agreements. So, George, first of all, thank you and welcome. Thanks for being on the program.
Pleasure to be here, Aaron.
The issue of non-disclosure agreements is all over the news today and has been for a number of weeks with President Trump. We're hearing about his attorney, Michael Cohen, the Stormy Daniels scandal, and also other instances where we know this has come up. We've heard about Harvey Weinstein and allegations of sexual assault and use of non-disclosure agreements in his cases, and others as well that we're hearing about, I think, more and more in the news. So I want to talk about that and understand what these NDAs are, and we'll use the Trump example to try to unpack some of these things. But first of all, George, and thanks again for being on Good Law, Bad Law. Tell us a little bit about yourself and your background.
Well, I'm a trial lawyer. I've always done trial law. And trial lawyers oftentimes don't choose their specialty. They kind of get led there by where their clients come from. And I just happen to get into an awful lot of defamation cases. I've done them for many, many years. And I've had some really big cases against some big-time defendants, which were a lot of work, a lot of fun. But it kind of put me on the map as the defamation lawyer.
Are there any sometimes these cases end up in confidential settlements, as we know, but are there any you can give us as an example?
The examples I'm going to give you were in headlines. I had a case against Sports Illustrated on behalf of Randall Tex Cobb, where they put out a big story when he was attempting a comeback that he actually participated in a fixed fight. It was totally false. The author was a first-time ever boxing author, really knew very little about the sport. She kind of got overwhelmed by things. We took it to trial after 9 years, got an $11 million judgment.
Wow.
For the defamation. I've had cases against the New York Times. I recently had a case against Universal Studios in their portrayal of Joey Giardello in the movie The Hurricane, where they showed a fight that Joey actually had with Reuben Hurricane Carter and purported to have Carter winning the fight pillar to post and Giardello winning the decision only because of racist judges. That was completely and utterly false. We sued them. So I've gotten into a lot of these kind of defamation cases because I started with some defamation cases, and it just one leads to another. Today, these NDAs and these sexual harassment cases, which are kind of closely related, because a lot of people that get accused of sexually harassing someone, the first words out of the defendant's mouth is, "You're libeling me, you're defaming me, I'm going to sue you."
Right.
So I've also gotten into a lot of that. And of course, the number one issue on everybody's mind when they're trying to defend themselves against a sexual harassment charge is even if there's not any truth to it, and usually there's a scintilla or more of truth. But even if there's no truth to it, everybody wants a non-disclosure agreement or an NDA. And the reason is they don't want their name, their picture, their story blasted in newspaper headlines and TV news, teasers and that type of thing as having been associated with this kind of conduct.
So you could see this, we're going to talk about President Trump, candidate Trump, now President Trump, and obviously if you're in politics, certainly at a high level, this would be something you'd be concerned about, but it could be other kinds of celebrity or actor, or the couple examples you gave are sports figures, but it could also just be anybody for personal, business, or whatever
It's a lot
reasons.
of people. I'll give you some recent examples that I've had. A prominent lawyer in Philadelphia, well-known lawyer. If it had gotten out, it would have been headline news. I had one against, I won't say the institution, but it's a financial institution in Philadelphia. It's of utmost prominence. The situation was particularly egregious. Again, non-disclosure agreement. So these non-disclosure agreement issues are not just confined to the Donald Trumps and the Harvey Weinsteins of the world. They're CEOs, they're community officials, they're podcast hosts.
Oh my goodness.
It's everybody. Everybody is
Right.
is in the fray, so to speak.
Right.
And the most important thing is the non-disclosure.
Right. Now, before we leave your background, I know the couple of examples you gave us of defamation cases both involve boxers, fighters.
Yes.
And tell everybody just briefly what your background is, because you have a special connection, not only as a trial lawyer, but you have a connection to the boxing world.
I do, and it's it's the same etiology or the same beginnings as trial law. People ask me, how did you get involved in boxing? Real easy. I got punched in the mouth. That's how most people get involved in boxing. So I was involved in boxing as a youth growing up.
In Philadelphia?
And in New York. And then as I got older and realized I better find a day job, and I became a lawyer, it came about that the Boxing Commission had an opening on it. And I was a big supporter of Congressman Ridge, who was running for governor. He won. When he did win, he came to me and he says, George, is there anything that interests you that might help my administration with? And I said, Tom, it's funny you should ask. And that's how I became the boxing commissioner.
Okay.
And so I kind of got into it because that's things that I was involved in and things that I knew about. And it was a fascinating position. And there are many, many issues there. And I have represented a lot of boxers in defamation matters, but I've represented a lot of business people in defamation matters. I've represented attorneys in defamation matters. I mean, defamation, can strike anywhere.
Right. Well, it's a good segue because we often think of ourselves as trial lawyers as the ultimate fighters, among lawyers. And court is the ultimate, stage where we fight.
The ultimate ring.
The ultimate ring, exactly. So from your background as a trial lawyer and as boxing commissioner and a fighter yourself, let's dig into this because it's fascinating. As we were preparing for to meet today, I did pull up the Stephanie Clifford, aka Stormy Daniels lawsuit, which was filed last month, and attached to it is the non-disclosure agreement that's at issue, and there's so much. We were talking briefly this morning about how we could really do an entire law school semester just on this document and all the issues that it raises. But as we lead into this, I want to distinguish and define what we're talking about, because as a trial lawyer, we settle cases all the time. Some, yes, go to trial, but many, many cases settle, and always with a settlement agreement, whatever the dispute is. And I would say 99.9% of the time, the settlement agreement has confidentiality language in it. So any agreement to settle a dispute a civil dispute is going to raise issues of confidentiality, but a non-disclosure agreement is different in some pretty material ways. So maybe we could start there. How is it different from the normal or just run-of-the-mill confidentiality terms we'd see in any settlement agreement?
Yeah, and confidentiality agreements also show up in business transactions and that type of thing. If you have private business affairs, if you and I, for example, Aaron, are going to work on the next best icon for internet access, it's proprietary. We want to keep it confidential because we don't want others necessarily to misappropriate our brain power and our ideas.
Right.
So you and I might have a confidentiality agreement. Those are not only common, they are encouraged. When it comes to a non-disclosure agreement, though, it almost always relates to some bad act. And the bad act is treated differently in the eyes of the law than, for example, you and I getting together on a great business idea. Bad acts, sexual harassment, rape,
Extramarital affair.
Extramarital affairs,
Yeah.
these types of things, particularly, Aaron, when it involves public figures,
Yeah.
a priest, a president of the United States or a candidate for president of the United States, a community leader, that type of thing. The law recognizes the public's interest to know what's going on with their community and to understand what their leaders are doing and how they are behaving. There's a recognition in the law that that's a matter of public concern. So you have that principle contrasting with a non-disclosure agreement, which is a contract between two individuals supported by the payment of money. So it's an enforceable contract. And the sanctity of contracts, which is also recognized in the law. So you have a clash of these two principles and what's going to win out. And these days, there's more and more pressure to say, no, listen, if it's a matter of public concern, and certainly the conduct of our President of the United States is a matter of public concern, we have a right to know. Can't just bury this stuff because you paid X amount of dollars through some private lawyers. And the non-disclosure agreements are now coming under increasing attack legally, by the courts, court of public opinion, that type of thing. So, to answer your original question, what's the difference? A contract to keep things confidential on something that's good between private business people, great, no problem. To try to cover up a bad act by a public official is an entirely different animal, and it's being more and more treated differently in the law.
Well, in this one, and we're going to go into some of the details of this, to understand how these non-disclosure agreements work and where the problems may exist. And let's be clear, this is not really anymore about did Donald Trump have an extramarital relationship with this woman. I mean, I don't think there's really anyone at this point who doubts that. And probably most of us don't care either at this point. I mean, the world has really changed since the days of Bill Clinton and certainly since, JFK in the White House. I don't think probably most people care. I mean, they might, his wife cares, I'm sure. But but the issue in this case is money that was paid to her for the non-disclosure of certain things and certain information. We'll get to the certain things in a minute because that's very interesting. But the payment of money to this individual, Stephanie Clifford, days before the election so that this information would not come out before the election. And to that extent, this non-disclosure agreement was successful because the information did not come out. but now there's a raid on Michael Cohen's office, and Trump has made certain statements denying certain things here, and they seem in conflict with other statements that have been made. So, you have the FBI investigating the Southern District of New York, U.S. Attorney's Office, the Mueller. I mean, this has become about a lot more than did he have sex with this woman. So we can put that aside I don't think anyone's that interested in that. But here we have a non-disclosure agreement for information and things about, as you say, the bad act here is, I think everybody agrees that it probably happened. Who cares?
Yeah.
But what you've now read this too, and obviously there's a lawsuit that's been filed by her attorney in California for a declaration by the court that this is not valid, that this non-disclosure agreement is not valid. So looking at it, what do you see as the key potential problems with this particular agreement that could have the court find that it's not valid?
I think there are a lot of issues here, as you just stated. I will say this is the most unusual NDA or non-disclosure agreement I've seen ever. First of all, it's done with pseudonyms. It's not done in the names of the real parties and interests. But it attaches and integrates a Schedule A, which does have the real names. Now, what the purpose of that, and if the NDA is going to get disclosed, the schedule is going to get disclosed. So I don't understand the whole pseudonym thing.
Well, I mean,
putting that aside for the moment,
I think that side letter, as they call it, which has the real names in it, they describe it as attorney's eyes only.
Yeah, but it's referenced in the non-disclosure agreement. So if you're an investigator or a prosecutor or something like that, you see it, you say, okay, give me the side letter.
Sure.
And it's got all the names in it. So let's put that aside for a moment.
All right.
One of the big issues here is the pseudonym David Dennison, who is supposedly Donald Trump, never signed the agreement. Okay? Now, that in and of itself doesn't mean it's unenforceable, because there is a concept in the law known as long as it's been signed by the party to be charged, it's enforceable.
What does that mean, the party to be charged?
Party to be charged means Stormy Daniels signed this. She's being charged with violating it by all of her public statements in the media about the affair. She's the party to be charged with the violation, and she signed it. And as long as she signed it, she agreed to it. Why is she allowed to breach it? So there's that concept. But there's public statements that have been made by President Trump and his attorney, Michael Cohen, which undermined that party to be charged concept. Mm-hmm. And that is, Trump says, I didn't know anything about it. And I didn't agree to that. So if that's the case, you can't have a one-party only agreement. Michael Cohen says, oh, I did this on my own. This was my money. Nobody authorized me to do it. I did this on my own. So if you take them at their word, then it is only a one-party agreement, and there is no such thing as a one-party. You don't have a contract with yourself. You can decide for yourself what you want to do or not to do, and you're allowed to change your mind anytime you want. You don't have a contract with yourself.
Right, right.
So there's that very big problem with this agreement.
So Trump didn't sign it, or David Dennison as Trump, or Trump as David Dennison didn't sign it. And denies
Michael Cohen did.
Michael Cohen did, but
is he an agent for David Dennison?
Well, that's something I wanted to ask you, actually.
Ordinarily, if he's the agent, it would be considered signed by David Dennison.
He could
but he made the public statement, I did this on my own.
Right.
He disavowed the agency.
So he could. So we know there's a concept called power of attorney. The attorney can sign for the client if he's authorized to do so. To do it. But in the agreement, it references Michael Cohen as the attorney for EC, which is some entity, Essential Consultants LLC, that apparently was incorporated days before this agreement was signed,
Right.
and Michael Cohen is indicated as signing as
On its
attorney,
behalf,
right?
yeah.
Attorney for Essential Consultants, and then there's a blank
Yeah.
on the form, on the agreement. There's a blank for where DD would sign his name,
Yeah.
and there's a blank for where attorney for DD would sign.
So who is EC? Who's the, if EC is an entity, any entity has to have a president, has to have some kind of a board of trustees or board of directors, that type of thing, and someone has to own it.
For it to be
Unless it's
legitimate.
a non-profit.
Or if it's
For
a
it to
sham.
be, yeah. So who is that person?
Right, we don't know yet.
We don't know yet. No one, that issue hasn't been addressed. I don't see anybody rushing to the New York Times or CNN saying, wait a minute, I'm EC, I own it.
Right.
So who gets to enforce this?
So theoretically, Michael Cohen could have signed for DD, but that didn't happen.
Didn't happen.
And it says that he's acted on his own, and Trump. And
Those
no
are
one in
his
the
oral
Trump
statements to the
organization knew.
media.
And Trump says, yeah, I didn't know about this. So,
And Michael Cohen says it's his $130,000.
right.
It's all bizarre.
Well, you've represented some pretty high-profile people in business, sports, et cetera, and you mentioned this. What about the fact that they use pseudonyms in the main agreement opposes an issue, do you think? Why is that potentially problematic?
Because it is, and again, when these things get judged, they get judged by human beings that are the judges. And a lot depends upon that human being's reaction to it. And when they proceed with pseudonyms like this, it gives you the impression that there's something more sinister going on here. This is just, it's hard getting past the smell test. Now, you're not going to see in the law books any legal doctrine known as the smell test.
Right.
But
Right.
if anybody's ever been in court and standing in front of a judge and trying to assert a legal position that doesn't pass that smell test, believe me,
You got a problem.
you got a problem.
Right.
And this has a real smell test problem.
So all right. So this agreement, if it's, first of all, it has to be a valid agreement or an enforceable agreement. That's an important word. And I just used it. What does it mean to say that it has to be an enforceable agreement?
Well,
Because you can put anything down on paper.
Yeah, you can put anything down on paper. If you and I enter into a contract, Aaron, let's murder Joe Blow. And I give you the money to do it. And 2 weeks later, I come by and say, Aaron, man, paid you the money. How come you didn't murder Joe Blow? You can then say, you have an unenforceable contract. Okay? The law will not enforce contracts that either call for an illegal act, criminal act, or are against public policy. Against public policy is a pretty broad term. What's public policy? Well, it's up to the courts to determine what public policies are, many times. And a lot of things can qualify as public policy. These NDAs are increasingly being attacked as being against the public policy of the public's right to know what their leaders are doing. So even if you get past all the pseudonym issues in this NDA, even if you get past all of the who didn't sign issues on this NDA, you then have to confront the issue: is any court going to enforce this? Because this is of utmost public concern for the public to know what their leaders are doing, and how are we going to say we're going to bury all this? And that's a huge, huge issue that I think ultimately, if I had to make a prediction, I think ultimately a court will say this NDA is not enforceable because it is against public policy.
And is that because it's Donald Trump who was a candidate for president when this was signed?
Yes.
If this was just two unknown people,
different
had no
public
high profile
policy
at all.
Public policy, You know, if it's Joe Smith and Ellen Smith, and they're not leaders and they're not politicians and they're not business executives and all those kinds of things.
Right.
They're just average folks. There's a far less public interest in knowing what those folks are up to than what our leaders are up to. Our leaders are our representatives. They do things that affect our lives. Joe, average guy, doesn't do things that affect my life or yours, Aaron. But Donald Trump sure as heck does.
Right.
And that's what gives rise to the public's right to know. And therefore, I think that if this agreement were between just two ordinary folks, it probably would not get struck down on public policy grounds. Now, it may have all the other defects that we've talked about, but I don't think it gets struck. But the fact that it's Donald Trump, I just cannot imagine a court ultimately enforcing this document.
Well, and I think that leads into the subject too of the payment. Lawyers would call that the consideration. What Donald Trump here is buying through this payment that Michael Cohen made is non-disclosure. And to do that, there has to be a payment of money, and in this case, it's a payment of $130,000. The question of where that money came from and who actually paid it, and did that violate federal campaign finance laws and all, does raise issues of whether the payment was lawful, and that's another problem with this agreement.
Absolutely, if it's utilized illegal proceeds, almost a money laundering type origin of that money, that's another big problem, because that would then make it not necessarily a contract against public policy, but a contract calling for illegal acts, money laundering, violation of campaign finance laws, and the courts won't enforce those kind of contracts either.
And indeed, it might be. That we think from the reports we've seen in the news, that's why there was or at least part of the basis for the raid on Michael Cohen's law offices.
Very serious, very, very serious issue, and let's not overlook the timing of this payment. This payment wasn't just made randomly on some day in some month in some year. This payment was made literally days before a hotly contested presidential election, which was obviously, and if you don't see the obviousness, I think you're naive or living under a rock, obviously meant to protect Donald Trump from adverse publicity in the presidential election. And if that's the case, then one can make a very strong argument that it was a campaign-related expenditure. And if that's the case, then it's illegal because A, it's too big, and B, it was never reported as such.
Right. So let's separate it from the time frame, because it is, as we know from just the timeline that we know was there. This was right before the election, only by a few days. Actually, the agreement was signed on October 28th, 2016.
Yeah.
So just literally days before.
Yeah.
And only a short time, maybe a couple weeks after the disclosure of the Access Hollywood tape that created such a storm, where Trump said lots of things that I'm sure he'd like to have not come into the public eye when it did. So the timing is really crucial in this particular case. But let's separate it out from the timing just to understand. If this was still something that involved Donald Trump, same guy, and he's a real estate magnate, but not president, and we remove it from the timing right as it was right before the election, does the public policy concern, do you think, still
No, it lessens
strongly?
No, it lessens considerably under those circumstances, and I think you've really defined it well, Aaron. That is the issue.
Yeah.
It wasn't just a real estate developer having nothing to do with an election, having nothing to do with Access Hollywood tapes and all that stuff. It's the president or the would-be president of the United States running for the most powerful office in the world that affects everybody's lives on a daily basis. And he's up to these kinds of acts and conduct which we as the public have a right to know about.
Right.
You know, there's another whole issue we haven't even touched on
Okay.
as to the enforceability of this document. And you and I were discussing it earlier. If, under the document, purportedly, if there is a violation, Stormy Daniels is subject to a $1 million fine for each and every violation. Anytime she mentions it, anytime she goes on TV. At this point, under the agreement, she probably would owe $50 or $100 million, okay? So now there's another issue here on the enforceability of this thing as to whether the law will enforce what is clearly a punitive, penal provision.
Right.
The most obvious example in the old days was, Aaron, if you owed me $100 and didn't pay me, I could sue you, have you arrested, and have you put in jail until you did pay me. The courts long ago did away with that.
I'm glad
There's a lot of reasons why that wasn't such a good idea.
Right.
Although whether it got you paid or not remains to be, I'm not sure what the history of that was either. However, the concept there is if something's really penal and punitive, courts aren't going to enforce it. They're going to put you in jail for 6 months because you owe George Bochetto $100. This agreement would purport to have Stormy Daniels owing millions and millions and millions of dollars for even so much as a comment about it. I don't think that's enforceable either. There's not a lot of people talking about it just yet in the media, but believe me, it's a very, very big problem for the enforceability of this agreement.
Could that provision of the agreement invalidate the entire non-disclosure agreement?
It could, particularly since I did not see in the agreement a severability clause, which is legal speak for a clause that says if a certain portion of this document is punitive and unenforceable, then the court can remove that provision and enforce the rest of it.
Right.
There is no such provision in this document. So ordinarily, if any portion of this document is deemed illegal in and of itself, then the whole document is bad.
Well, and this is the main threat that's hanging over her head if she does violate. And again, this is a non-disclosure agreement, so she's not to disclose, according to the terms of this agreement, the confidentiality of what happened, which is some relationship. But also there's reference in the beginning of this agreement to certain things that she may have or that they may have had together. It talks about not only confidential information pertaining to DD, David Dennison, but some of the information is in what it says is what it describes as tangible form, which includes, quote, but is not limited to information, certain still images and or text messages, which were authored by or relate to DD. So it's not only disclosure of the fact of this relationship having happened, but whatever are the tangible, even electronic messages, text messages, emails, pictures, we don't know what.
Absolutely, right.
So she can't do anything with any of that, or she violates.
Well, under the agreement, it was supposed to have all been turned over to Michael Cohen.
Right.
Now, there's been some suggestion out there, I don't know whether it's got credibility or not, but there's been some suggestion that there is a Lewinsky-type dress that exists. Was that turned over to Michael Cohen? Mm-hmm. Under the agreement, if it existed, it was supposed to. If it was turned over to Michael Cohen, do the feds now have it because they raided his offices? We're going to see. But yes, all those would be violations, calling for the $1 million per violation penalty.
And to get, I mean, we're talking about the legal aspects of this because these concepts that we're talking about relate to all kinds of situations beyond just this one. But just to come back to the issue of the $1 million payment per violation, it's in the section of the NDA called remedies. And really only David Dennison has remedies in this agreement.
Right.
There's nothing in here that allows her to recover if Donald Trump or Michael Cohen violates this agreement. All the remedies, relate to what DD or Donald Trump would get. And it's in the section, the $1 million payment is in the section called liquidated damages. Now, I think lawyers know that even the idea of liquidated damages is often frowned on in contracts like this. But there's a way of evaluating whether the liquidated damage could be realistic. Like, for instance, if you had a real estate contract, a lease, and you default, you're the renter and you default, the landlord can fast forward to the end of the contract all of the rent payments that you would have had to pay. That would be a kind of liquidated damage. The court probably would uphold something like that in many instances.
Yes, right.
But so what is it about $1 million per violation or breach of this agreement? I mean, the language in the agreement says that $1 million is a, quote, reasonable and fair amount of liquidated damages to compensate DD for any loss or damage resulting from each breach. And she signed this. She initialed each page and she signed it. So doesn't the signing of it make it reasonable?
Well, you raise a very interesting point, and yet another basis upon which this document can be attacked, and that is this document what's known as an adhesionary contract, meaning that it is so punitive, it is so one-sided, it is so overboard in the remedies that will befall even the slightest breach, that the law has a concept known as if the parties are in unequal bargaining positions, and one has a proverbial gun to the other person's head and says, sign this confession or else, and you sign the confession, nobody pretends that confession is legitimate.
Right.
These kinds of contracts are so overly one-sided and so punitive as to the party with the lesser bargaining power that the law could actually declare it an adhesionary contract and thus unenforceable. $1 million per violation. So how does that $1 million arrive at? Can Trump prove that he lost $1 million of income? If she said it 3 different times in the same day, did he lose $3 million of income because it was 3 times and not 1 time? I mean, it becomes almost comical in terms of its application if taken literally. I mean, I don't know how many times she's been on the media in the last few days, or her agent, her attorney, which is attributable to her. Let's say it's 100 times, and I think it's probably far more than that.
At least that, yeah.
At least that. $100 million of damages to Donald Trump? Sounds hard to believe.
So how do we, I think there may be some people who could hear this conversation and would say, look, she knew what she was getting into. She had an affair with Donald Trump, even if she didn't know he was running for president.
And she took the $130,000.
Right, and she took the money.
She said she'd keep her mouth shut.
Exactly. So some would say, what's her problem? She knew what this was. Others might say, this is almost by definition, an unfair contract because there's a threat that is built into this.
Right.
It doesn't look like damages. It looks like a threat to ruin you, to
absolutely.
And that. So how do you balance those things in this agreement as we see it in front of us, or in these agreements generally?
And we have seen, both you and I have seen, Aaron, in many court decisions where, for example, a court might say, for all of the reasons we've just discussed, we're not going to enforce this contract. But then the court adds another provision to its opinion. It says, however, this does not mean that we countenance the behavior or think that Stormy Daniels is in any way herself praiseworthy or a hero or that type of thing. The fact of the matter is she was having an extramarital affair. She knew she was doing that. She knew she was doing something that was dishonest both to her husband and to Donald Trump's husband. And on top of that, she went out and got a lawyer and then secured for herself a $130,000 payment, which isn't chicken feed.
Right.
And now we're supposed to feel sorry for her?
Because she wants to have this undone so she can go talk about it and probably
make
a lot
more money.
Exactly.
But see,
She's not,
the court, I mean, strictly speaking, on legal principles, the court can't get bogged down in that, even though that is the elephant in the room. I mean, we have maybe one of the worst actors in the, possible or imaginable, saying this shouldn't be an enforceable contract. She is not, by any means, the hero in all this. She may be a victim to some extent, but she was a very willing victim, and she took the money.
Right. Still, we're looking at a contract, and I mean, you can't think about what's happening with Donald Trump and this whole saga without, I think, reflecting back on Bill Clinton and Monica Lewinsky, because Bill Clinton, after all, was impeached for what happened with Monica Lewinsky, and those who were his critics and his adversaries in Congress would say, well, it wasn't the affair, it was his lying about it. The lying about it was the crime.
Right.
And here, and I tried to set this out in the beginning of our conversation, I mean, we're talking about, obviously, some salacious acts here, which, again, I say, really aren't the issue. I mean, I don't care, really, what he did or didn't do and what she did or didn't do. But it's the nature of this agreement and what it says and how it is used in these situations that I think is really what people ought to understand and be concerned about. In Donald Trump's case, it might very well be campaign finance fraud or crime. That's what's being looked at right now. So the enforceability of this and the way they tried to structure this agreement may help us understand what actually was going on. In other words, not an affair. That's not the point. The point is Donald Trump and his team had a reason for wanting this to remain hidden during a crucial time period.
That is absolutely...
That's the issue.
That is the issue, because, stated another way, if this had come out 2 weeks before the election, that there was this porn star, that they had this relationship, that he hired a lawyer to try to cover it up and so on and so forth, would Donald Trump still have won the election?
Right.
That's the issue.
And since the agreement itself clearly refers to things, not just facts about what happened.
Memories.
Who knows what? Right, memories. Who knows what could be circulating in the news media? Pictures, text messages. Who knows? I mean,
absolutely.
Think of Anthony Weiner, who ran for mayor and was married to Huma Abedin, who was the close aide to Hillary Clinton.
Yeah.
He was finished when those pictures came out. There was no way he was going to come back. That was it.
Absolutely done for.
And now we live in an era of social media, and everyone's got a phone with a video and a camera. I mean, this is the future. If this is how people behave and try to deal with this kind of conduct, right? I mean, there's pictures, there's text messages, they don't go away. So where do you see this going? I mean, you've already told us the problems with this NDA.
Yeah.
And I think you'd be hard pressed to look at the actual document, which, by the way, we will post a link to in the description of this episode because it's a public record now. And you can't look at this, I think.
So your question is, where are we headed?
Yeah, because this is clearly, how do you defend this agreement?
I'll give you a little, insight into it. Most people don't realize it. There was a tax reform bill that just got signed into legislation by Donald Trump. A little known portion of the Tax Reform Act says if there is a confidentiality or a non-disclosure provision in any case involving payment for sexual harassment, those payments and the legal fees that you incur are not tax deductible, even if it's in connection with a business. So the Congress has already started to weigh in on this and say, we don't like these things, and if you think you're going to get a tax deduction for this $130,000 that you're trying to buffalo us all with, you're crazy.
Yeah.
And I think you will see, as a result of all this, no matter how it ends, I think you will see either on a state-by-state basis or on a federal basis, I think you're going to see legislation, specific legislation, declaring that these kinds of NDAs and these kind of bad act cases are no longer lawful or enforceable. And that'll put to rest the entire debate over it. You just can't do it. So then, if you're confronted with these things, the ramification is going to be as follows. The only reason Donald Trump or any other person in his position will pay $130,000 is because they think now they can buy silence. If there's legislation out there that says you can't buy silence anymore, it's illegal, then the Stormy Daniels of the world aren't going to be able to go to the Donald Trumps of the world and stick them up and say, I want, big money to hush. So then you're going to affect whether there are any kind of hush agreements in the first place. You can't have them. So that the Stormy Daniels of the world will either have to go out and try to get their publicity or not, but they're certainly not going to be paid for it. And I think that's where we're headed.
Mm-hmm. Well, I don't know. Is that a good thing? Because you can imagine a world before these types of agreements where there might still have been a payment. They might have given her some money, or whoever's coming forward, or who you're trying to keep quiet about whatever issue. And you might give them $100, and then the next day they show up and you have to give them another $100. I mean, it could go on. The point of any agreement like this
is its enforceability.
Is its enforceability and its finality.
You're right.
This is meant to put an end to this issue. And if you don't have a way of doing that by contract, then the issue's not going to have an end to it.
You couldn't be more right, and I'll give you the flip side of it. Let's say you do have an illegality of these kinds of NDAs. No longer can you have them or enforce them or enter into those kind of contracts. Someone comes along and makes an allegation. In the old days, even if it's a public figure, it's a one-day newspaper story. 6 months go by. Who can find the newspaper? Right. Nobody.
Right.
Today, everything's on the internet, and you can research things on the internet about people from 20 years ago. And all this stuff hits the internet, and it's with you forever.
Right.
Unlike the old days.
So who knows? There's all kinds of ramifications you could see, and what impact this has on people running for elected office, for people
running big companies,
sports figures, celebrities,
priests, monsignors, across the board,
lawyers,
prominent lawyers,
right,
everything.
Incredible.
You almost want to advise your clients, keep your mouth shut, keep your hands in your pocket, and go home at night. Don't stop at that corner bar for a couple of beers.
Well, that is probably good
advice. You're only going to get in trouble.
That is good advice, actually. George, thank you so much for being on the program. This was a great conversation, and I hope people will listen to it and share it with their friends. Really good stuff. And as I said, we'll post a copy of this NDA between PP and DD and EC, otherwise known as you know who.
Right.
George, thanks so much.
Pleasure, Aaron.